And this is how Justice Clarence Thomas is a sellout. Because right now he's talking about the constitutionality of affirmative action having no place based off the Constitution in the regard of the integrity of the country to maintain its status for equality. But at the same time, simultaneously, he's also talking about firearms. And the Second Amendment specifically states that it shall not be infringed. And then he goes on to say that permits are legal and valid, even though there's no laws that are on the books based off of the historical perspective and during, and then a little bit after the Second Amendment. And then it was specific individuals like states or municipalities that enacted some form of a permit to subject citizens to be unable to carry concealed and required a permit specifically. But the reality of the situation is, to this day, right now in 2023, we still have specific states and municipalities which enact laws which are unconstitutional. They're in place for about 10, 20, maybe 50 years before a lawyer or a specific case or somebody with a certain amount of wealth, or power, or prestige has the ability to challenge that law, and then it goes back up to the Supreme Court, and then it's ruled invalid and unconstitutional. Now, Supreme Court Justice Clarence Thomas stated that during or following the ratification of the Second Amendment, there were specific states who discriminated against black people, specifically slaves, and even their white counterparts who were looking at the unfortunate reality and the discrimination based off of these race-based laws, which were not applicable, nor were they enacted before or during the Second Amendment. So for him to say specifically about the context of the constitutionality and the historic perspective of the Second Amendment in comparison to affirmative action, he's a hypocrite, right? What he's done specifically is he sided with the white side of society, and not just in a racial perspective, but in a prejudicial perspective, because the reality is there is no context. As a Supreme Court justice, to say that there's no history for it based off of history, right? And then to recognize and acknowledge the fact that the only history is based off of post ratification of the Second Amendment. But we all know that municipalities and laws can be enacted post anything and be unconstitutional, and then they're set in stone for a very long, prolonged period of time until they are challenged, which we see right now. I mean, look at it, like affirmative action. Look at slavery. Look at Roe v. Wade, Brown v. Board of Education. There are so many laws that have been in place after the Constitution, which were in place for up to 100 years or more, in which have been found unconstitutional. So to say specifically that a law which is passed post-Constitution or ratification of the Constitution or post-ratification of an amendment is constitutional because it was accepted after the ratification, even though there's no prior history to it, to say that that's applicable, to say that's appropriate, is inconceivable, right? Because that within itself is a complete fallacy. So, the reality is what we're seeing specifically is, we have a guy who's in office who he's a bitter individual. And unfortunately, he's probably also a very biased individual. I don't know what for or what from. There are allegations of ties of him being buddies with the three main components of wealth, power, and prestige, which run a society, a capitalist society. So the reality of the situation is, we're in a very dangerous situation to where, we have people who are not standing up and upholding the laws and the integrity of the country and the Constitution. And it's just very unfortunate because the reality of the situation is just going to where there is no vigilance, there's going to be tyranny or one-sided oppression, because that's the way it works. If you're not vigilant, you get rolled over. That's the way it is. If you don't stand up for yourself, somebody, and you hope somebody's going to stand up for you, then the reality is somebody's going to roll you over. And that's the unfortunate reality of having individuals who are past their prime. Not necessarily their age, but their fighting spirit, right? If you don't have the fighting spirit, you should not hold a position of leadership, because you are going to compromise each and every time, which is going to make every one of the individuals who fall under you susceptible or vulnerable. And that's what he is. This guy is past his prime. So, that's my 2 cents. The reality of the situation is, it was a travesty about the Second Amendment, because the Second Amendment specifically says shall not be infringed. And then when you look at the specifics of the evolution of the firearm from black powder to what we have now, percussion cap, when black powder existed, every firearm was concealed. 90% of the time it was concealed, because the mechanics behind the firearm were so flawed that if it got wet or if it was too humid outside, it wouldn't work. Do you understand that? Like, even when you look at the specifics of the firearm, whether it was a rifle or a pistol, because we didn't have trunks all the way back then, all we had was boogies and horses, you didn't leave your firearm unattended. And if you did leave it unattended, you sure shit didn't leave it out in the open where people could just walk up to your horse and take it off your horse and walk away with it. No, you kept it covered and concealed, right? Even when you look at the attire back then, living on the eastern seaboard in the 17 and 16, 18, 1500s, you were wearing a large piece of cloth because it was so cold, right? Probably multiple layers, because we didn't have a lot of technology back then. So if you did have a pistol, if you were fortunate enough to have a pistol or a knife or a sword or a cane knife or a cane sword, a rifle, whatever the situation was, 90% of the time it was concealed. And there were no permits before the Second Amendment. There were no permits after the Second Amendment for at least maybe 20 to 50 years. And the reality of the situation is, it was common sense to do it, because at that time, you could only shoot one round at a time. So you weren't going to walk around town with a firearm with the idea that you may have to use it to defend yourself from a savage Indian, quote unquote, or maybe even just a wild animal, because we were still taming the frontier, right? Or it could have been, pirates were still a real thing back then. So were looters and robbers and thieves. I mean, people used to get hung, shot to death. These are tumultuous times. So if you had a black powder firearm, you only had one round. So you had it loaded and ready to go. So you had to make sure that it was ready to fire when you needed it, immediately when you needed it. So you had to recognize that it was loaded, that it was a dangerous weapon. And you had to recognize that if the black powder got wet inside the catch pan, then the fizzing wouldn't spark. It wouldn't cause a spark to ignite the black powder, which caused the explosion to project out the round. And so what you're saying specifically is, for hundreds of years, people weren't aware that if a firearm got wet from, say, rain or snow or just being in a humid environment, that they were okay with taking a chance of putting their life on the line based off of a firearm that they knew was faulty when wet, right? Or they were going to take, up to 2 minutes to reload a firearm that got wet because they didn't take the time to consider that historically, with their father, their grandfather, or with themselves, that when their firearm previously got wet, it didn't fire. I mean, people did practice shooting, so I'll guarantee you this was common knowledge. And to prove that it's common knowledge, the first sets of firearms, which were black powder rifles, were modified, and they were given not a single but a double rain catch pan, because it was problematic about how the black powder will get wet. So they added a second chamber for a double rain catch pan to try to prevent it, to try to make sure that the water wouldn't fill up in just one, but maybe it would pass from one to the other, and therefore it would preserve the integrity of the black powder, so it would still ignite based off of when the frisson slashed against the metal to create the spark. And so this is the reality. This context specifically about how black powder was unusable, even in wartime setting. There was a case, I think it was General Gage of some sort, I believe, something like that. But there was a large munition of black powder that got wet and was unable to be used on both sides during a very specific war. I can't remember the specific war here in America. And so what ended up happening is, because when it rained and nobody expected the rain, the munitions that were being utilized by black powder became worthless. So they had to cease fighting. There was no more fighting for the rest of the day until it finished raining. And then they had to readjust both sides and figure out what to do to continue fighting. This is the harsh reality. There are not a lot of historical battles that have been fought in America during the rain, especially pre or during Second Amendment ratification. Because if it rained 99% of the time, you wouldn't be able to fire your firearm because everything would get wet. So you had to keep it concealed. So if you're going out and about and you're a regular citizen, just, going to hunt, if you were going into town, if you were going to buy new land, if you're going exploring, whatever the situation was pre-Second Amendment or during Second Amendment, or even maybe 20 years after the Second Amendment was written and ratified, if you had a rifle or a pistol on you, you did not keep it open. You kept it concealed, right? And that's just the unfortunate reality. Permits are infringements. That's the truth. So, when you guys are talking about Justice Clarence Thomas, a black man who specifically quoted inconsistencies and discrepancies and discrimination against black people in his dissent about the recent Second Amendment ruling, for him to come out specifically and say that affirmative action is unconstitutional, then the reality of the situation is you have to look at the guy for what he is. He's incompetent. And not to say that he's intellectually incompetent, it's just to say that he's morally incompetent. He has no more fight. He's given up. He's throwing in the towel. Right? And that's not what you want for a Supreme Court judge. That's not what you want from any leader. Someone who's going to roll over. You want someone who's going to stand up and fight and make sure that the rule of law is upheld. So, take this for what you want. You can do your research. There's a lot of data out there. It really is. But, hey, man, I'm signing out.